So let's start with the Blurred Lines case and talk about that article. There was a lot of, in reading back through it myself, there's a lot of technical stuff in there that I don't necessarily expect you to have followed exactly. And that's one of the reasons we're not having a quiz this week. I just wanted you to get the main idea of the article and just have it be sort of thought-provoking rather than paying attention to the sort of minute details of it. Had anybody, before we talked about this article, all of y'all heard the Robin Thicke song, Blurred Lines? Has anybody not heard that? You not heard it, Bernard? It's all right. You want to sing it for us? Somebody sing it? I'm just kidding. Had anybody heard the Marvin Gaye song? You had, Miss Marshall? What were your initial thoughts you've heard both songs before. Did you were like, yeah, I can see where those are similar, or?
From the first notes, it sounded similar to the Marvin Gaye song.
Did anybody go back and listen to them?
Listen to Blurred Lines again, but not the other one I showed.
Yeah. I don't think I've ever, I guess I've probably heard the Marvin Gaye song, but I didn't go back and listen. So, this case was about those two songs, and Marvin Gaye's estate sued Robin Thicke and Pharrell Williams and I think T.I. For copyright infringement. And so when we were talking about this last week, usually copyright infringement in music, the music will share the same sequence of notes or pitches or duration of notes. It's something that you can pick out and be like, oh yeah, that's sampled from that, or that sounds very similar. What's interesting about this case is that the songs don't even have, according to your article, they don't have similar melodies. They don't share one single melodic phrase. They don't even have a sequence of two chords played in the same order for the same duration. They have entirely different song structures. So I'm going to pick on Ms. Marshall then, since she's heard them both. How in the world could we have copyright infringement when we don't have those kind of similarities in these songs? And you've already kind of hit on it. But when you listen to them, what was it that made you think these are similar?
Because it was played kind of sort of in the same way. It was like the whole thing was based off of that one. Not even knowing that they didn't have permission, but it was so close to it. When I heard it, it was like, wait, because there's a lot of other songs that are like that.
Mm-hmm.
Like, you basically use his song to make your song.
So that's was sort of the heart of this article, was that Marvin Gaye's estate was, or the result of the case is basically saying that now not only can you not copyright a certain sequence of notes, but you also now can't sort of copy a style. And the critics of the result of the case are saying that that's problematic, because all music is derivative of prior music. I mean, not all music. A lot of music is derivative of prior music. If you ask any recording artist, they're going to tell you who their influences are. Where their sound came from, what they base it on. And so in that way, how can an artist ever be certain that they're not committing infringement of copyright just by using somebody's feel? On the other hand, the critics would say, we can never have, if we can't copy somebody's feel or vibe or kind of style, then nothing is original. So this was an unusual case in copyright. Usually you would go to court, you would play the similar chords or the similar sequence of notes or whatever, and you'd be like, oh yeah, it sounds the same, or that doesn't sound the same. They didn't have that in this case. So it was more of a same feel than it was exact same notes. What do y'all think about that? Thoughts on that? You heard both of them, Miss Marshall. What do you think?
You should give permission, I mean,
You feel like you feel like it was copied.
it really.
Similar enough to make you feel like, oh, you ripped them off, or you should have had permission. And I know everybody else said they didn't necessarily listen to both songs, but what about the idea that you could copyright a certain style or vibe? That strike anybody as problematic?
Yeah, but there is some truth to being able to copy that, and I don't know, if it's not, I know you can say it's not directly chords and lyrics, but I don't know, sometimes you hear a song and you're like, they're just, trying to steal somebody else, but at the same time, at what point does it stop? And people will not create great songs because they're scared of I guess getting Marvin Gaye.
Yeah, you getting Marvin Gaye. It's kind of like it reminds me of the Supreme Court quote when this is decades ago. They had a pornography case, and the justice said, "I can't define it, but I know it when I see it." So, same thing with sort of copying a style. I might not can tell you what the bright line test is, which is what that article was arguing for. I might not can give you a great definition of when we cross the line from kind of influenced by to copyright infringement, but I know it when I hear it. I get that. The quibble I would have with that is ears are different. Miss Maxwell might could hear it, but I could listen to them and say, I have no idea. So I get the gray area in there. Robin Thicke and Pharrell appealed. So this went to trial, and the jury decided that the songs were too similar, or were similar enough that they should have gotten permission. And then it got appealed. What happened on appeal? Anybody remember from the article? The appeals court upheld what the trial court had decided. So Pharrell and T.I. and them lost on appeal as well. So that stood. So now the estate of Marvin Gaye gets a portion. I can't remember what all they had to pay. They had to pay a pretty significant amount, I think, of the profits they had made off of Blurred Lines. They had to share that with the Marvin Gaye estate. Any questions on that case? No, I know we're not as likely to read a case if we're not being tested on it, so I get that. Let's move to your examples of lawsuits involving intellectual property. So I have a new mic system that has multiple mics, so I'm going to, so whoever's speaking, I can toss this to and we can pass it around. You're unpacking, so I'm gonna start over here with Mr. Cochran, and we'll work our way backwards from there. You don't have that? It's on. You don't have to clip, you can just hold it somewhere in your so the assignment was to find two examples of a lawsuit involving intellectual property. Could have been copyright infringement, could have been trademark infringement, trademark dilution, theft of trade secrets, all of the categories that we talked about last week. And so what I kind of want to know from you guys in your assignment is just tell me the basics of it. And then if we have questions or want to get deeper, we can. But just kind of tell me what the category was, what happened in the lawsuit, what it was about. We'll go from there. All right, Mr. Cochran.
So my first one was Bowman v. Monsanto, the agricultural biotech company that was acquired by, I think it's Bayer in 2018.
Okay,
They sold him genetically modified seeds that could survive through an herbicide, and he took the seeds that he got from his first crop and then replanted them. But they sued him for patent infringement because when he originally bought the seeds, he bought them under a limited use license.
okay. So they licensed them to him. He used them, and then he used them in a way that was inconsistent with the license or inconsistent with the permission.
Correct. And they claim that he infringed on their patent. for
And the
genetically
patent
modified
was,
seeds.
the design in the patent was the genetic sequence of the seeds or however.
Yeah, they could survive like an herbicide. You could
Okay.
spray Roundup on it.
So basically they designed seeds that would survive an herbicide.
Right.
So that means I guess you could spray or it'll kill the weeds and not your crop. Okay. All right, so what happened what was the result?
It went up to the Supreme Court and they ruled unanimously in Monsanto's favor that it was patent infringement.
What was the argument that it wasn't?
He claimed patent exhaustion, where when a consumer or like someone sells something to someone, the patent is void,
Okay.
so that you can't then like sue somebody for being in possession of that patented item.
Okay.
And they said that did not fall into that.
Okay. Interesting. All right, you got another one?
Yeah, my second one was Whitmill v. Warner Bros. If anybody's seen The Hangover 2, there was a tattoo artist who sued Warner Bros. For copyright infringement because they used his art as someone, like a tattoo on someone in their movie.
All right, and what was it? Do you remember what the tattoo was?
I don't remember exactly what the tattoo was. I think it was a face tattoo though.
Had you seen The Hangover 2?
I have not seen it.
Anybody seen The Hangover 2? So what happened? What was the result?
Warner Bros. Tried to claim fair use, even though it was like a copyrighted art, and the case was settled outside of court.
So somebody got paid a little bit and it all went away.
Yeah.
Remember, the fair use exception is when you can use something that's copyrighted without compensating the author, like an educational, we talked about the exceptions, educational use, if you're writing a movie review or something. I'm not sure exactly how fair use would have come into.
Yeah, it doesn't make much sense.
That
It's
make
probably-
much sense because they're making money off that,
But that's probably why they settled out of court.
and probably why they ended up settling out of court. You're right, Mr. Cochran. All right, good, thank you. Any questions about either of those cases? All right, we're going to pass it to Ms. LaFavor.
So I kind of misunderstood the assignment.
That's all right. Tell us what you got.
I did them all. I gave
Okay.
2 examples for all because I didn't understand, but
That's what. Yeah.
I did that at first too. And I was like, because I was like, it's better more because if
I got a question about it last night, and so
The way
that
I read it, it made it seem like we had 2 examples for each one. It's
I'm-
the first way to do it.
I'm sorry. You did too. I'll give y'all some extra credit. How about that?
sounds good.
We y'all some. I feel terrible about that. I'm sorry.
I'm sorry.
Most people are idiots, and I'm one of them. So you don't have to apologize. It's my fault.
No, it's really mine. And I even called my mom and she was like, yeah, I think you got to do them all.
Well, pick out the 2 you like the best.
Okay.
How about that?
Okay. So mine is trademark dilution.
Okay.
And
Trademark dilution. So this is not the outright just copying it, just jacking. Okay, go ahead.
so my first one was Tiffany and Company versus Costco. So apparently, Costco was like misleading their customers, and they were selling rings, and it just said Tiffany. It didn't say in company. So Tiffany was like, a lot of customers were coming like back and saying, hey, like this isn't Tiffany and Company. So I guess word got back to Tiffany, and then they sued Costco, and Costco was ordered to pay damages to Tiffany, and yeah,
And they were ordered probably to stop suing those, stop selling it like that?
yeah.
How similar was it just the word Tiffany, or were there similarities in the logo, or?
I think it was just the word Tiffany, but also like, I don't know, know, cause it's a designer company, so if you see Tiffany and
Yeah.
you have a blue box or whatever, I'm pretty sure anybody will go crazy for it.
Did the Costco jewelry have a blue box?
Yeah, I think so, yeah.
So they were trying to rip off
They
Tiffany.
really
I mean,
were,
I
yeah.
mean,
Yeah, I don't know who gave the A-OK for that one.
okay.
And
All
my
right.
second one was Gucci and Guess. And apparently the logos were like similar,
Gucci and Guess, is this infringement or dilution?
Delusion.
Okay.
And Gucci won in the US, but Guess had won in Italy. So I guess it was two different lawsuits. And if you shop, you know that there's logos actually do look similar. So yeah.
But that's interesting. Guess won in the Italian court, and
Mhm.
Gucci won in the American court.
Yeah.
Who sued who?
Sorry. So Gucci accused Guess, so Gucci sued.
All right, and then did you check them out for yourself to look and see?
Oh yeah, I mean that's well yeah.
So-
I'm like into shopping and
So
stuff.
what do you think?
Yeah.
If you're on the jury, you say it's too
I
similar.
would say yeah. I mean, to me, maybe this is gonna be controversial. I believe in buying. I don't, but I believe in buying dupes than going down. If that makes sense to me, which is probably worse, but I just feel like Gucci has earned their name. Guess is still one of those. It's like, oh, I can afford it, but it's just. Does that make sense?
Okay,
Yeah.
that makes sense. Y'all following that? My ladies are shaking their heads.
Yeah.
Y'all pull up Gucci and Guess. Tell me what you think about the similarities in the logos. What, Madison? She just smiled. What?
They're definitely
Too similar?
Yes, for sure.
Anybody want to be on the side of not similar? Nobody?
There's a cheaper version of
Yeah.
these.
Yeah.
The affordable version for us.
This, so you would expect the Guess logo to be a little cheaper knockoff of Gucci, basically.
But I know.
All right. So maybe somewhere deep down in Guess's business model, they're like, we want to position ourselves to be a knockoff Gucci, a discount Gucci. All right, pass that on if you will. Thank you, Miracle. All right, Ms. Robinson, pick out your two favorite.
Well, for my first case, I just had to the trade secrets and copyright.
All right, this is theft of trade secrets.
Yes.
All right.
And it is Motorola Solutions versus Hyperion Communications Corporation.
All right, what happened in that case?
So basically, Hyperion went and hired a bunch of Motorola engineers, but before they left Motorola, they had them download a bunch of their information and blueprints to, I believe, the radios.
So they hijacked a bunch of employees and had them bring with them. That seems like a pretty straightforward case of theft of
Yeah.
trade secrets.
Yeah,
How,
and,
how did they prove that? It just,
they didn't say how they proved it, but I guess once the line of radios came out, they were like, whoa, wait a minute, you know, it's,
that's too similar to
Yeah.
a coincidence.
and they won, but they went and, had to get them out produced, so I guess they rethought it, and then they got them out produced, but they won the case as well.
Motorola won the case. Did the other people just have to pay them a lump sum, or did they also have to quit manufacturing those radios?
From whatever end, they just said they paid them. I don't think Motorola released the radios themselves, I think that's really just gonna get paid.
Okay,
Yeah.
that's a good one. All right, what else you got?
And my second one was the Tiffany and Co.
Okay.
And the Costco wholesale case. Yeah.
Any thoughts on that we hadn't covered?
Yeah, so Costco's argument was that the term Tiffany was used generically for the style of the ring and not, yeah, that's the argument they tried to use. And it didn't work.
It's just hard for me to That's really smart for me to accept.
Yeah, it is, so.
Alright, I'll take down. To Miss Marshall. Alright, what you got?
Well, my first one was along the same lines as, the Blurred Lines case.
Okay.
It's copyright infringement.
Of music?
Yes.
Oh, okay, alright, good. Tell us about that.
So, basically, Vanilla Ice, was sued by Queen and David Bowie for his use of, similar beat and things to Under Pressure, you know, against Ice Ice Baby,
Okay, so Ice Ice Baby was the song.
was the song.
Vanilla Ice got
You all heard
sued.
that one?
Mm-hmm.
Yeah,
Now-
you know the first beats when it drops.
Yes.
And, I know y'all probably haven't heard Under Pressure.
I have.
You have?
Yes, and
So
it's like,
it's identical.
Oh, it's identical?
When you hear the first opening notes of both of them,
yes.
it was too close for it not to be.
So how did, how do you think that got all the way to trial then? Like, what was Vanilla's argument?
He said he used a different, string of notes, in a different beat than, they did, but he did not. The judge didn't buy that.
Didn't buy that.
Yes.
This is one of them that when you hear it, you just know it.
Yeah, and I went back to listen to Under Pressure, cause I knew I heard that beat before, but you know, back in the nineties, I'm like, wait a minute.
So Under Pressure was David Bowie and who else? Queen.
Queen David Bowie,
Okay.
he wrote the song, so, Vanilla Ice used that without their permission, you know, and he was sued, what was it? He had to pay a private settlement of, $4 million plus song credits and everything,
So they probably got some money going forward.
yes. So.
Might have been worth it to Vanilla Ice though, right? Without that song, he.
Well, his reputation didn't make it after that, so he's been,
He's like on reality TV
yeah.
for a while, and then now I haven't heard. Wasn't he like renovating houses on reality
Yeah,
TV
he
or
was.
something?
Every time I heard those beginning notes, I always looked to see who was on aux playing, and if they were like above a certain age, I'd be like, it's Under Pressure, and then if they were like below, I'd be like, it's Ice Ice.
I mean, it's an iconic song that
Yeah.
he definitely made. I would say made that phrase more popular, more famous than Queen and David Bowie. But
And that case basically paved the way for the other songs that happened afterwards. So that was one of the first ones of the copyright infringement.
gotcha.
So
Interesting. All right, what else you got?
as a former employee versus Apple. So what's his name? Zhao Lang.
This
Basically,
theft of trade secrets.
Theft of trade secrets.
All right.
So basically, an employee of Apple said he was going home to take care of his sick mother, but before he left, he took confidential documents of self-driving vehicles. So basically, he went back home to work for another company and gave those documents to them. And Apple basically terminated his access to their information and went back to check all of their records on his access to see what he did while he was there. And they saw that he was taking, all that information from them. So he did, use it as his new job.
One of the things that jumps out to me when I hear that is that I don't know that I've got the patience or the energy to run a big company. Like, how am I going to keep them from stealing stuff? And then if they do steal it, what my remedy is? I've got to go hire a bunch of lawyers and sue them. Ugh, it's exhausting. So,
So he received a 120-day prison sentence.
oh, he went to prison for it.
Yeah, 3 years, supervised release and a restitution fee.
So he went to prison. That tells us that there was more than just a civil suit involved. That means that he got some criminal charges as well. So the state of California, I'm guessing,
I think so.
prosecuted him for stealing the trade secrets. So the civil penalty of paying the money was the least of his problems if he went to jail for quarter of a year, third of a year. All right, any questions, thoughts on that? All right, pass it on up to Mr. Hare. Tell us what you got.
My first one is trademark infringement.
Trademark infringement.
Louis Vuitton sues Louis Vuitton back.
Oh, this is the Korean one we were talking
Yeah.
about, right? All right, tell us about this.
So Louis Vuitton sued a South Korean fried chicken restaurant with a very similar name. The chicken restaurant was charged with name infringement as well as having too similar of a logo and packaging. The logo was pretty much just straight up Louis Vuitton. And they sold in the box, it was Louis Vuitton chicken. They were forced to pay, I think it was like 14 million and it was like 100,000.
And to stop, right?
Yeah, they just,
I mean, to stop using it.
it was a straight rip off.
Right. So did your article say what they did next?
No.
So depending on which one you're talking about, the first time the chicken restaurant got sued, they just changed the wording. They changed the name. Yes, and they just changed the wording around or something, right? And then,
Change their logo, it's still very similar.
and Louis Vuitton went after them the second time and got them to stop that too. Yeah, I agree with you. I've seen that logo. It was straight up.
It's funny to look at it. Louis Vuitton with chicken.
that was the ripoff. It was fried chicken in a box, and Louis Vuitton was who they chose to. That is interesting. All right, that's your first one. What's your next one?
Second one is theft of trade secrets. Hooters sues Twin Peaks.
Twin Peaks.
So Hooters sued Twin Peaks and former Vice President Joseph Hummel for taking trade secrets from the cyberspace to Twin Peaks.
Cyberspace.
That was the wording in the,
What did they actually steal?
it was like advertising secrets and how to keep recruiting girls, I guess.
So it wasn't. It didn't have to do with the logo or branding or naming or anything like that. That's where my mind went first. I was like, I mean, okay,
Well, I don't think that's what trademark, well, the article said the restaurant space.
gotcha. Okay.
But nothing came of it, they settled outside of, no one knows what they
No,
settled.
it's a private settlement. All right. Any questions on that? All right, pass it on down to Mr. Wilmot.
Thank you.
We'll see what Florida has for us.
Alright. I did a copyright infringement case between Taylor Swift and Sean Hall and Nathan Butler.
All right, who are those dudes?
Sean Hall and Nathan Butler are songwriters, and they claim that Taylor Swift, in her hit song Shake It Off, stole the lyrics, haters gonna hate and players gonna play. Taylor claimed that these lyrics were far too broad and not original, and the judge agreed, saying that they were way too basic to be protected by copyright.
What do y'all think about that? I agree with that too.
I mean, like lyrics, unless it's like it's a direct rip, I
Yeah.
would say is very hard to claim copyright on. Like it's basically like the songs American Idiot by Green Day, American Psycho by Trail Predator, and American Jesus by Bad Religion. Like, they all say American in the title,
Yeah,
and like they all go court over it.
yeah. You can't copyright the word
It's
American.
Like one of those bands not even being American.
Yeah, it's just too general, basically. That my first reaction to that is that's not similar enough. But I guess they were taking a big swing at a rich person,
Yeah.
and if that suit had worked out, or if she'd been willing to settle, they would have cashed in some.
And they also claimed that she said it like more than once, which was like kind of rubbing it in their face. But I agree with the judge and the ruling. But I also like, if this case went the other way, I wonder how many hit songs that came out would not be out right now.
Well, and that's sort of what I wanted y'all to start thinking about in that blurred lines case. Is if you're a recording artist, does that start making you pretty nervous about? I mean, you know, I woke up in the middle of the night and I wrote this melody. Did I hear that earlier in the day, subconscious? I mean, you know, where'd it come from? So,
Like a creativity case.
yeah. All right, what else you got?
I have Naruto, a monkey, and PETA versus David Slater. David
A
Slater-
monkey.
Yes.
A monkey is the plaintiff?
Yes. Well, on behalf of PETA.
Okay, I was about to say, I'm understanding how a monkey has standing, but go ahead.
Yeah, that's part of part of it.
All right.
And Naruto, the macaque monkey, stole David Slater's camera and took a selfie on it. And here's the selfie.
Oh, that's fascinating. And
Y'all probably
so,
seen it before.
Oh, yes.
oh, that's Naruto?
Yes. the
That's your
monkey.
favorite meme? Now you know the story behind it.
He stole the camera, took a selfie, and that was that until David Slater started making real good money off of that picture. And he just said that picture is property of Naruto, the macaque monkey. And the judge dismissed the case and said that Naruto is a non-human entity, and so he cannot be the owner of the
That
entity.
he did not have standing.
Yeah,
So that was the result of it? Was
Yes.
that Naruto lost out on that?
and Naruto beat him. But Mr. Slater did promise to donate a quarter of his earnings on that selfie to.
Okay, that's fair.
It was his
to
camera,
the macaque.
right? What do y'all think about that?
I think if I was in Dredge, I'd be like, "Okay, I'm done."
Well, Naruto, so one of the problems with if the court had allowed the monkey to win the suit was then where do you draw the line? If I take a picture of a tree outside, is somebody going to sue me on behalf of the tree? I mean, you know, it's not a monkey, but they're both living things. So where do you kind of draw the line on that? I had not heard of that case before. That's a great one.
Does the monkey show up in the suit?
What if, like, I know, like, this is crazy, but the judge just said just because he was non-human. So, like, what if that monkey? This might sound crazy, but like, you know how monkeys be tapping and stuff. Like, what if that monkey was adamant? Would it still just be like you're non-human? You're just non-human. You know,
What if the monkey was what?
just like adamant, like this
Oh.
is my selfie.
Like he can talk and stuff?
Let's just say that. Would the judge still be like you're just non-human?
Maybe sign
Probably
language.
so, because I think I just,
Maybe sign language saying that's.
what would the monkey get?
Like, he can't get money.
I mean, yeah, what would the monkey's damages be? Money, I guess, but then somebody would have to be appointed to hold his money. And I mean,
How's he gonna spend it?
you see where
Banana.
this is a slippery slope is what they call that in the law. That's a very slippery slope if we start allowing animals to recover.
True.
But that's a really good question. All right, you guys, I wanted y'all to do some stuff from your home country. If y'all are not prepared for that today, we can do that Thursday. You need Thursday?
I did 2 American ones actually.
You did do what now?
2 American ones.
Okay, you can, if you have them, do you as well, Elias?
Yeah.
Yeah, you have American ones?
Yeah.
All right, let's just do those. All right, you're up.
So the first one I have is trademark infringement, and it's the party Starbucks Corp and Wolfsboro Coffee.
Okay.
The dispute is Starbucks sued Wolfsboro for selling a coffee called Charbucks.
Charbucks?
Yes. And it claimed it infringed on its trademark.
Okay.
And the resolution is the court ruled in favor of Wolfsboro because stating that Charbucks did not cause confusion with Starbucks.
So Charbucks won.
Yes. An interesting fact is the case emphasized the importance of distinctiveness in trademark law and how descriptive names can lead to disputes.
Huh.
Charles was a drink.
So were they both coffee?
Yeah.
Was there any similarity in design or the wording or packaging?
I mean, it's Charbucks is like basically kind of sounds like Starbucks.
Right.
I wouldn't agree to it, but I mean, this is what the,
What was their logo?
yeah.
Oh, here we go. It's like a.
Was the company?
It's like a Pokemon.
It
Drink.
was just like
Ooh, it's green and black
Yeah.
it. Yeah.
and round. Eee. But Charbucks won, huh? Okay. All right, what else you got? That's a good one.
The second one is trademark dilution, and it's the party's KFC Corp against the Kentucky Fried Chicken shop, also like kind of similar.
Okay.
The dispute is KFC argued that the use of Kentucky Fried Chicken by a local business diluted its trademark.
Okay,
And the resolution is the court ruled that the local business's use did not constitute dilution to its specific regional context.
it did not. Where was the Kentucky Fried Chicken located? The baby one, the little one.
Where it was local, I think it was like kind of close to it.
It was somewhere in Kentucky.
Yeah.
So that's like if I opened a chicken restaurant here and called it Columbus Fried Chicken.
Yeah, and then like one is opening right next to it, which kind of the same name.
I'm having a little heartburn over that one. I think that if I'm KFC, I'm not happy with that.
An interesting fact is the case demonstrates the challenge of protecting trademarks on a national scale when a local business use similar names.
Okay,
Is what you should do.
interesting. So if the little Kentucky Fried, the local Kentucky Fried Chicken was located in Korea, then we've got more of a problem, right? Because they were using, that was part of their defense was, I'm in Kentucky, I make fried chicken,
True.
right? And so that the local part kind of
Yeah.
saved it for them. Interesting. I still think that's ripped off, but respect what the court had to say. All right, pass it on.
For infringement, I found a case in 2012 from Nike versus Already LLC. In this case, Nike sued already that the company's selling clothes with similar design and logo.
All right.
The Nike trademark.
Did they?
swoosh.
So the other company had the swoosh as well?
Yes, I did not find the picture unfortunately, but they were claiming that they were using a really similar, their trademark design.
Who
basically.
won?
So what?
Who won?
Nike eventually, and the court ruled for them and affirming that Already's use of logo infringed upon Nike's trademark rights and would like mislead consumers regarding the source of the product.
All right. So they had to stop.
Yeah.
All right. What else you got?
And for the dilution, I have Mato versus TAM in 2017. So Mato is basically standing for Misha K. Lee, who was the Undersecretary of Commerce for Intellectual Property and the Director of the United States Patent and Trademark Office.
Okay.
So this is basically, she was the one that was the face of the USPTO.
Okay.
And versus Tam, who is Simon Tam, a leading vocalist of the band The Slants. So in this case, an Asian American rock band called The Slants sold the trademark for their name, which was considered a derogatory term for Asian individuals.
Okay. So they wanted to trademark a name that was a racial slur, kind of.
Yes.
Okay.
And the U.S. Patent and Trademark Office, the USPTO, initially denied the application, citing that the name could be seen as disparaging.
Okay.
Disparaging.
All right. Disparaging. Yeah.
Disparaging, yeah. However, the band argued that by using the name, they were reclaiming it and not causing dilution of the trademark. The Supreme Court ultimately ruled that the USPTO's refusal to register the trademark was unconstitutional,
Oh.
affirming that the name did not dilute the distinctiveness of the trademark.
Okay. Who trademarked it originally? Like who owned the trademark?
I wish I could say.
So they so somebody trademarked. So the name in and of itself, it has multiple meanings.
Yes.
It's not just a derogatory name.
Yes.
All right, and so it went all the way to the Supreme Court, and they said you should have allowed them to trademark it. Interesting.
Yeah.
Okay. All right, good. Those are good, Benny. All right, Sadie, just pick out two good ones.
Okay, well, the only two I have is the Louis Vuitton versus Louis Vuitton's
You got the chicken one, okay?
Tiffany and Company.
Okay, we've already talked about yours. I thought you said you did 2 for each category.
No, I started out
Oh.
doing that, like when I started the assignment, I found 2 cases for each one, and then, like, I read through it more, and I was like,
Oh,
Lord,
okay.
you're talking to me.
All right, I was gonna say, if you got,
So I ended up only doing it for 2.
gotcha, okay, and we've talked about your 2. Anything that you wanna add that we hadn't talked about on those 2 cases?
I feel like with the Tiffany company one, I know it was like trademark pollution, but, cause they were using the name Tiffany, but I feel like they shouldn't just be able to have that color. You know what I mean? Especially cause that company or that product, it was the same color and name, but they were selling, dry cleaning plants, like they weren't even selling jewelry.
Oh. So the whole thing was, not even jewelry?
No, but I mean, they did have the name Tiffany, even though it wasn't any company, and then they had the same color, but.
So you think if they hadn't had the same color, they might have been
Well,
okay
yeah,
on
for sure.
that?
They didn't have the same color, the color's the biggest part, because Tiffany and Company's going after a couple of, brands trying to use that color.
Is the issue only color, that color blue?
Yeah.
But
Is
it's
there
just
a way
like,
for
I mean, if they
brands
can
color?
choose to only have that color, then other brands can choose to only have this color, and then it gets.
It does get, it
They
does,
pay for the color though,
Yeah,
like
some
you said, they
companies
own
It's the same thing
it.
with green.
It's like, that's their right.
well, I mean, because,
Turquoise is blue.
because it's associated with Tiffany. Like, I mean, I do think that like a UPS truck could paint themselves a color close to that. Or, I don't know, but you're right though, it does get into problematic if everybody's gonna pick a color and nobody else can use it, then, you know, where do we go from here? All right, Laura.
So I did a French cake,
Okay, good, we got a French case. All right, what you got?
and it's Louis Vuitton and another brand that's called Eau de Baby Dog.
Okay,
And this company is making toys for dogs.
dog toys.
Yeah.
Okay,
And so they created kind of like dog toys, like and it's called Louis Vuitton.
shit, okay.
And so Louis Vuitton sued the brand because it was the same pattern. They were using the logo and the design. So Louis Vuitton was the plaintiff, and they sued them for trademark infringement. And the U.S. Court of Appeal ruled for Hot Dignity Dog because they said it was humoristic and it wouldn't confuse consumers because it wasn't bad.
So it would not confuse consumers because just nobody's gonna think that a dog toy is actually Louis Vuitton.
Yeah.
But you said the logos were similar.
Yes.
What do you
It's
think?
not Louis Vuitton, it's Chewy.
Chewy Vuitton. I mean, that's a rip off of Louis Vuitton if you ask me, but
Yeah.
Chewy Vuitton, all right. So they, who was the French company? Chewy Vuitton?
They're both French.
Oh, they're both French. But I thought you said somebody in the U.S. ruled. I just misheard that.
Okay, yeah, so maybe Hot Dignity Dog is US.
Okay, but it was in a U.S. court.
Yeah.
Okay, gotcha. All right, that's interesting. All right, pass that one on. Bernard, you sent me some logos. I mean, some trademark stuff.
Yeah, I think how some don't bring out.
But
It's like South African trademarks.
okay, I can pull them up, or you can turn your laptop around. What do you think's the fastest?
I think that was me. The logos.
Oh, you did some trademarks too?
Yeah.
Okay. I didn't, I'm trying to think, I tell you what, I'm gonna come back to y'all on a different day, cause still got a few people to get to. So, because it's gonna take me a while to pull it up. I'm gonna let y'all talk about those, we'll just do it on a different day. Pass it on down to Andon. And Mr. Meyer, you did exactly what I asked you to do and emailed them to me last week, so I appreciate that. I recognize that. I see you.
Alright, my first one is exactly what you guys did, the Wolfboro Coffee and Starbucks. The whole,
So now you're ripping him off. All right, got it.
well, none of this has to be better. But the main one I did was Apple versus Samsung.
Okay.
Yes, Clash of Titans. It was on patent infringement. Apple sued Samsung claiming that Samsung's smartphones and tablets copied Apple's iPhone and iPad designs, infringing on several Apple's patents. And these are the exact ones. The rounded rectangular shape, home button placement, and various software features like Tap to Move.
The rectangular shape?
I mean,
Okay.
I-
What other shape's it gonna be?
It's bull crap.
So this went on a long time, didn't it? This case?
So it was solved in 2012, but 2018 is when it finally settled.
6 years of litigation?
Well, 2012 is when the first settlement was done.
Okay.
2018 is when everything was set in stone, finished.
So what was the resolution? Who paid
The
who?
jury awarded Apple over $1 billion in damages.
Wow.
It was later reduced. After
Figures.
several appeals, they finally settled in 2018. With Samsung agreeing to pay an undisclosed amount.
Okay.
My money's on $500 million.
Probably so, probably pretty much. Interesting. All right. Good job.
Basically, this case highlighted the complexities of global patent laws and was notable for shedding light on how design patents can protect the look and feel of products. So, yeah, don't make a phone with a rounded rectangular shape.
So patents can not only be like a specific technical recipe or something, it would also protect the look and feel of the product.
Nintendo's going after a game developer for making a game where you throw something and out comes a monster, similar to Pokemon.
I gotta tell y'all,
And they're wanting $1 billion.
if somebody told me I had to go into intellectual property law litigation, I just would quit. I mean,
His court case, the first thing in my head when I heard his court case was, is that the last round of Cards Against Humanity?
Loki one?
Yeah.
that's just,
You ever
it
play that game, that's what that.
makes my head explode. All right, Mr. Henry, what you got? Thank you, Andon.
So my first case deals with copyright infringement, and it's between plaintiffs Atlantic Recording Corporation, Capitol Records, and Electra Entertainment.
Okay.
The defendant is Lime Group LLC. So LimeWire is a file sharing program that
Oh, yeah.
peer-to-peer technology that allows its users to share any digital file stored on the user's computer. A user just simply enters a search criteria. If there's a file that matches the criteria on another LimeWire's user's computer, the user can download any file from that search.
Anybody here used LimeWire before? This is a while ago, wasn't it?
So you heard this case?
Oh, yeah. I think I used it.
Yeah. So the problem of LimeWire, they allow any user to download music for free without the record company receiving
Yeah.
any compensation.
Right. Skipping out the people who
It
own it.
reminds me almost of like Netflix, how back then you can like have one account and that person can share with a bunch of people
Yeah.
without having to pay a subscription.
Yep.
That was like the beginning of the transition to digital music.
It was the beginning of the transition to digital music. You're right. And that was 20 years ago.
Yeah.
And so we're dating ourselves, Miss Marshall. But yeah, you could. I mean, like those things have disappeared now. But that was Napster and all that kind of stuff. And did LimeWire get shut down?
No. It doesn't say it got shut down, but it said the court ruled in favor of the plaintiff
Okay.
because they did commit copyright infringement.
Yeah. We were downloading people's songs without
Right.
paying for it. Yep. All right, that's a good one. I'm gonna just let you do one if you don't mind,
Okay, that's fine.
just cause we're going close on time. Sage, do you have an example for us? Hold on, I'm gonna let you. There you go. Gotta be on the mic.
I did so there's a case over the rights to the Happy Birthday song. So in 1935, I think, some company bought the rights to the Happy Birthday to You song. And then in 1980,
did not, for 50 years, I did not know that I was
Well, I guess I gotta go ask more about it from my
ripping off somebody, whenever we sang happy birthday. All right, that's a good one. Just in the interest of time, I won't let y'all more than that's okay. Steve, what you got?
In my case, it was a trade dress infringement.
Okay, trade dress, so appearance of the product.
Author of the book, Piano for President, he used Jack Daniel's black whiskey bottle label
Okay,
on his book cover.
I think I've heard of this.
And pretty much what happened is they sent him a letter, and they were like, if you love our whiskey enough to use it on your book, we're sure you'll understand that this might harm our image, and we're hoping to take it down and change the reprint. And he just changed it on the next reprint. They told him they'd give him some money if he did it by a certain time, but he didn't accept it.
So on his book cover, did it say Jack Daniels on the bottom?
No, it said Piano for President, and then like where it says number 7, it was like a hamburger. It was like a comical book
But
kind
if
of.
you looked at it, you would be like, that's the
But
Jack
you would know
Daniels
for
label.
sure, yeah.
Gotcha. And so he did change it on future editions? So everybody's happy?
Yeah, basically what they said was so interesting about it was how it was handled.
That they actually worked it out and were friendly about it? That is an interesting, that is, they didn't end up having costly litigation, so.
Right.
All right, real quick, Mr. Alexander.
Alright, so mine was on trademark infringement,
Okay?
the case involved Louis Vuitton that.
Yeah.
Louis Vuitton being a fashion brand, and Louis Vuitton that being a South Korean fried chicken restaurant. The dispute was that Louis Vuitton argued that the restaurant's name was similar to the brand infringing on its trademark.
Yep.
The resolution was that the court favored the Louis Vuitton, ordering that the restaurant change their name and branding to avoid consumer confusion. This case highlights how trademark protection extends beyond the same product categories to protect brand identity.
All right, so that's, we've got Louis Vuitton and Chewy Vuitton today, and Louis Vuitton Duck. Yeah. All right, good. Nathan.
I'm covering Nintendo versus Gary Bowser.
All right.
Essentially, there was a Gary Bowser who was working with a team called Team Executor to hack Nintendo consoles. And the thing is, he and his team got caught for it. And what turned out to be a massive, like, both criminal and civil case. Where essentially, because Gary Bowser and his team were selling dockets that you could plug into your account. Because, like, Nintendo has all their games copyrighted, and they don't want you, like, selling them, or, like, giving them away for free. Not distribution. So, it's an issue where, like, this guy and his team just start selling people tools that allow them to get games for free online.
Ah,
Yeah. Copyright infringement. So,
kind of like LimeWire.
yeah, so like because of that, he and his team got sued. Like he specifically got sued in the civil case for $10 million was the final restitution he had to pay. And that's on top of the criminal suit that the U.S. government filed against him, which is unfortunately, they charged us for like $4 million.
Whoa.
Yeah.
But he got the double whammy of civil suit and criminal suit.
Yeah, his life was basically over.
But he was hacking consoles and putting games on those consoles, right? That's what he's doing?
Well, he was giving people like tools that allowed them to hack the consoles.
Maybe it's complex.
Did he come out ahead in the money?
Well, he definitely didn't make more than like $14 million.
That was my question. Was it worth it?
No, definitely not.
Definitely not. All right. Sorry for keeping y'all a little bit late, but be on time on Thursday. We're going to start on time because I got a guest speaker, and he's going to speak on criminal law. And so if you have questions, I mean, I'm going to handle most of that, but if you have questions, I'm encouraging you to speak up and answer. So I'll see y'all on Thursday. Good job.
Mr. Chivo, I was looking hard for a case where like someone got traded from one team to the other and like told them all
the trade secrets?
all, like, secrets.
Did you know the Astros and Cardinals had that?
Oh.
There was a guy who I don't remember which team stole what, but they had their proprietary player evaluation something.
Yeah.